Welcome to this Hey Legal exclusive. Content that will keep you up to date and informed about the important legal issues of the day. Time is of the essence, so let's begin.
Ronnie, thank you so much for joining me. For those who don't know you, I'll just give a brief introduction. So, Ronnie is currently the president of the Scottish Criminal Bar Association. He is recently appointed as the Vice Dean of Faculty, and congratulations on that. And you are also a member of Lady Dorian's Restarting Solemn Trials Working Group. So it has been a busy time, to say the least. I think today we're going to try and cover a number of pressing issues that are facing the criminal bar currently. We're going to start with a discussion about the proposal of Saturday courts, which is exercising the profession, and then we'll look at the position regarding solemn trials and the various different models that have been scoped out. So, Saturday courts, can you give us your thoughts and give us an update, please?
Well, I suppose before I do, I suppose I should put a disclaimer to say that any views I have may not necessarily be the views of faculty or indeed the Criminal Bar Association,
Sure.
And maybe my own opinion. But I think it's also important, although you've explained where I am now, I was in private practice. I was a solicitor in private practice for 12 years in Glasgow, predominantly at the criminal side of the bar. So I do understand the pressures that are upon, the solicitor side of the profession. So I'm not looking at it just from a counsel point of view. So far as Saturday courts are concerned, at the moment, obviously it's just a proposal. I can understand why the profession are up in arms about it, because I suppose first and foremost the question will be, well, remuneration, how do we get paid for this? Are we going to get paid for this? Because as I understand it at present, the way the legal aid regulations are, there's nothing that takes account for the fact that a trial may be held on a Saturday. And you are looking at the very real prospect of a solicitor sitting in a court all day on a Saturday, only for a trial not to start. And in effect, you would get paid nothing. Am I correct in that? Yeah. Is the way the current regulations are?
As I understand it, there's a block fee, obviously, in relation to preparation and everything up to the trial, but thereafter, at the time of the trial diet, if you were to attend and thereafter not be taken or adjourned later in the day, there's no increase. You're simply given another date and told to return.
Yeah, and I suppose the thing about that would be that certainly I'm sure the court employees and the fiscal service won't be doing it for nothing. So I suppose in some ways the question then is, well, why should solicitors? Yeah. I think part of the problem is that I'm not quite sure that those who make these regulations or who propose them understand the details and really understand the problems that are faced by the solicitor side of the profession. And of course, they can say, well, we can have Saturday courts. It will mean, I suppose, that they will have to pay a bit more in overtime to their employees or whatever. I don't necessarily think it's just that they haven't considered the profession. I think in many ways it's they are ignorant of the pressures on the solicitor and the payment method. And if I was still in the profession, if you're asking me, well, what's the solution? I think first and foremost, and what my recent involvement with government, with the courts and everything else is, that it's all very well shouting, no, you can't do that, we're not having that. But I think it helps if you actually explain why you're not in favour of it, why it wouldn't work, and why you are against it. And also then, if it is something that's going to happen, then what you would have to do is put forward your proposals to make it happen. And by that, I mean proper remuneration, for example. Because I think most people would think it would be unfair to expect people to hang about all Saturday and receive no remuneration for it whatsoever. And of course, it will be something that when these regulations were introduced, SLAB would not have in mind, and the government wouldn't have in mind, solicitors sitting in a court on Saturday, other than when we do it, or when we used to do it for custody courts, but certainly not for trials.
Yeah.
So I think the first approach is to explain the problems.
Yeah, I mean, I think I've tried to gauge feelings in the profession, obviously in advance of talking today, and clearly the remuneration is a factor. It's always been a factor really in recent decades, but there's also just the practicalities around it, which is that, you know, many firms now operate on a shoestring in terms of personnel, and essentially you've got a core working week, which can be the entire day in court, returning to the office, custodies in the evenings, telephone calls, the prospect of being out in the early hours with a serious offence and then returning into court. And then the idea of obviously adding in a sixth working day into that mix when there isn't other personnel in the firm who can take the slack, that really that, you know, for a profession which has obviously operated during lockdown, they've kept the custody courts going, they've done these things. And then I think the issue is around those practicalities combined with just the question of whether or not people can just actually be heard about what's proposed. You know, the whole consultation process that's been talked of, is it one that will really genuinely take into account the thoughts of solicitors who are at the coalface?
I suppose that's actually something that we were just touching on there, the fact that all those problems that you've highlighted, or all the difficulties that you've highlighted, the question is, do those who are making these proposals know about these things? And therefore, really, it's incumbent upon the profession, I think, to let the authorities know what the problems are, rather than just say, no, we can't do that, we're not prepared to do that. Explain why. In my experience, when you actually sit down with the other side and you explain to them where the difficulties arise, then they are prepared, in my experience so far, they are prepared to listen. The other solution, of course, is by making other proposals. If you have got any solutions, if you have got any proposals to address the problem that's, for example, Saturday courts is trying to address, then again, it helps if you bring to the table suggestions, solutions, rather than just say, no, we're not interested. And listen, I don't know if there are any solutions. But there's usually a way that can be found in order to address any problem. And again, that's something that I found, it's all too easy for people to say no. And by this, I'm not talking about solicitors. I'm even talking about when we were addressing the various issues, the problems that were put up by the Scottish courts, by the government at each stage. And they did put up problems at each stage. For example, a classic one was, well, we can't have jury trials because we can't bring 100 people into court because there's no way we can socially distance for 100 people. And our solution to that was, we said, well, okay, that's fine. Don't bring them into the court. Don't bring 100 people near the court. Why don't you just ballot them remotely? And of course, we now find that that is the solution, and that is what's going to be happening. And is, in fact, happening now for trials in the High Court.
Yeah. I mean, are you aware of this? And you may not be, Ronnie, but obviously in the paper that was released by the Scottish Courts and Tribunal Service, COVID-19, Respond, Recover and Renew, they referenced in relation to Saturday courts that, you know, consultation would be required with the legal profession and other justice and third-party organisations to resource this model, and it would be unlikely to commence until April 21. So do you know, I mean, in terms of trying to get momentum around any solutions, because clearly as time goes on, the problem increases, are you aware of any consultation process being set up or started, or are we just talking theoretically here?
When they say consultation, again, it's often the case that there's consultation with parties, but for want of a better expression, the defence fall quite far down that list. And I don't think it's conspiracy. I don't think it's a conspiracy theory. I think that we have just fallen so far out the loop that we're not often considered when it comes to these things. And I think that the profession, I think it would help to raise the profile and our voice within government and within the authorities. And when I say that, I don't mean by shouting and bawling and protesting. I just simply mean by letting them know that we are an important part of the criminal justice system. Without us, it can't operate.
Yeah.
Whether or not we're always given that status, I'm not quite sure. But I think the answer is, I can't tell, the Law Society how to do their job, but certainly I think if you were to approach them and arrange to have a meeting, then and just get them to confirm what is the consultation process. The problem, and again, I'm not being critical, but the Law Society, I suppose the advantage that faculty had over the Law Society is that we're a much smaller organisation, and I suppose to that extent we're a bit sleeker, whereas the Law Society is a big organisation and it takes in a lot of members, and in some ways that's its weakness, but it should also be its strength, because you should be speaking with a much louder voice. Mm. And for example, we discussed this. You have the Glasgow Bar Association, you have the Edinburgh Bar Association, the Aberdeen, all the various bar associations. But at the moment, they're all sort of separate. If there was a way of getting them together and then maybe speak as one voice, my view that would certainly help. My feeling is it's much more effective to speak as one voice rather than a whole lot of separate voices all shouting separately into the middle of the room. And that was one of the advantages that we found in this whole process at the start, when we started initially objecting about non-jury trials. And there was a decision made fairly early on, and I have to say, the Law Society came on board. They were slightly slow at the start, but that wasn't for anything other than the fact that the Law Society tends to do things by committee. That was always the way it was. It was the way it was in my day. And in any organisation where things is done by committee, it takes just that little bit longer to get momentum up and going. But we felt that at the start that the Law Society and the Criminal Bar Association, the faculty, we actually had a common ground here, and that we'd be much more effective by getting together and speaking in one voice. Yes. And I think that's one of the real positive aspects that have come out of this whole pandemic for the legal profession, in that I think that in the past there's been a tendency for a sort of them and us type attitude, and I like to think that has disappeared to a large extent, and I think there's now a recognition, certainly from the faculty and the Law Society, that where we have a common interest, then we should cooperate in relation to that, rather than just two of us shouting from the touchlines.
We hope this Hey Legal exclusive content has been of value to you. Hey Legal exclusive. Follow us please on YouTube and Twitter, and create a free account on our website to stay informed and entertained about Scottish legal matters as they happen.